The next witness is Mr. Kell.
Mr. Kell. Kell, again, having excused you last time, I'm afraid we must ask you to either make an oath or take an affirmation again. Which would you prefer to do?
An affirmation, Commissioner.
Affirmation, if you wouldn't mind standing. Thank you so much.
Please repeat after me. I solemnly and sincerely declare and affirm
I solemnly and sincerely declare
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Mr. Kell, do sit down. Yes, Mr. Collinson.
Mr. Blazers. Your full name is Peter Kell.
Yes.
Formed in a telephone.
Your position is Deputy Chair of Asic.
Yes.
And would you give the Commission your, well, I think your work business address is 100 Market Street, Sydney, New South Wales.
Yes, it is.
And you have there, I believe, a summons to appear before the Commission dated 6 August 2018.
I do.
I tend to that if the...
The summons to Mr. Kell, Exhibit 5.317.
Now, Mr. Kell, do you also have with you a copy of your witness statement?
Yes.
Could I take you, please, to paragraph 37?
Yes.
You'll see in the last line the words "due to be released soon,"
Yes.
referring to this relationship statement. Should that correctly read "now published on ASIC's website"?
Yes.
Could you handwrite that in, please, and delete the words "due to be released soon" and then initial your change?
Yes.
And one last change, paragraph 195 on page 54. It's
Yes.
really the same point.
Yes.
In line 4, do you see the words "are releasing"?
Yes.
That's again referring to the same document. Should it correctly read "have released"?
Have released. Yes.
So if you make that change, adding those words and deleting the words "are releasing" and initial that.
Yes.
With those changes, Mr. Kell, is your witness statement true and correct?
Yes.
I tend to that.
Exhibit 5.318, the witness statement of Mr. Kell. Yes, thank you, Mr. Collinson. Yes, Mr. Hodge.
Thank you, Commissioner. Mr. Kell, I want to just start by understanding a few particular factual matters that you explain in your witness statement in relation to particular entities. If we go to page 22 of your statement, that's asic.0800.0013.0022.
Yes.
You're dealing there with some steps that you took in relation to NAB and Newless.
Yes.
And you make the point that in 2017, ASIC imposed additional licence conditions on Newless following ASIC's inquiries into several breach reports that had been lodged by NAB's wealth entities.
That's right.
And those breach reports relate to two things. One is the charging of planned service fees to members of the MKPS and MKBS where there was no linked advisor.
Yes.
And the second thing is some changes that were made to TPD insurance.
That's correct.
And as a consequence of those things, ASIC was concerned and had sought from Newless and NAB either an enforceable undertaking or alternatively a change to licence conditions.
That's correct.
And it had originally sought that in about July of 2016.
Around that time, yes. I don't have the exact date, but around that time.
And ASIC's position was that it would be, its preference was for an enforceable undertaking?
I think that was the starting position, but I don't think there was a strong preference for an enforceable undertaking or a licence condition. I would say in this instance they are very similar in terms of what they would achieve.
You understood that a licence condition was regarded as being less serious than an enforceable undertaking?
No, in fact, in a range of other instances, it's generally put to us that a licence condition is can be a stronger outcome than an enforceable undertaking. To give you an example of that, when there was concern around the issues that had arisen with Commonwealth financial planning's enforceable undertaking and the way in which there had been failures to comply with aspects of that enforceable undertaking, ASIC took the step of imposing licence conditions to address the failures that had arisen with the enforceable undertaking. So licence conditions may, in some circumstances, be more onerous. In this instance, I would have to say that the sort of outcome that was being aimed for was relatively similar. You had a public outcome, you had a range of requirements for the licensee to undertake and implement, you had a third-party expert who had to oversee that and report on it, and so on. So reasonably similar in terms of the outcome, but certainly I don't think we have a hierarchy that says licence conditions above, EU's above licence conditions, or indeed necessarily vice versa.
Your view is they will achieve a similar sort of outcome?
In this case, yes. In other cases, licence conditions may indeed be more onerous. My understanding that is in some cases the imposition of licence conditions requires wider reporting requirements by the entity to other regulators. So in those circumstances, licence conditions can actually represent potentially a more onerous outcome.
Can we bring up asic.0036.0002.0927? This is a letter of the 23rd of August 2016 from ASIC to Ms Smith, the Chair of Newless, and Mr Hagger, the Chair of National Wealth Management Services Limited.
Yes, yes.
And if we go to page 3 of that document, you see at the top of the page, paragraph 8, ASIC is rejecting a proposal that has been put forward by NAB and Newless for negotiated commitments. And it says, finally, ASIC does not consider that negotiated commitments are an appropriate way to resolve its regulatory concerns for the following reasons.
Yes.
A, we again point to the number and nature of breaches and their recurrence, which suggest that a stronger and enforceable response is required.
Yes.
B, an enforceable undertaking is an appropriate regulatory outcome in the circumstances of our concerns.
Yes, yes.
And C, an EU is an administrative settlement and the mechanism we would ordinarily use to resolve serious compliance concerns, even in circumstances where a regulated entity has complied with its statutory obligations to report any breaches, has cooperated and has been prepared to acknowledge ASIC's concerns.
Yes.
And is that subparagraph C factually accurate? Does that reflect ASIC's position?
What it reflects, I think, is that we typically obtain enforceable undertakings more regularly than licence conditions in these circumstances. But that is not a reflection, as I said, on licence conditions or enforceable undertakings indeed being one or above the other. It's simply a reflection of the reality in terms of the outcomes that we often take in these cases. I mean, if you look at 9, you have the note that licence conditions reflecting similar obligations are an alternative option.
Yes, 9 says the alternative basis upon which ASIC is prepared to resolve its concerns without enforcement action is for Nulis to consent to licence conditions reflecting similar obligations as under an EU.
Yes.
And taken together, what those paragraphs seem to suggest about ASIC's position, at least as at August 2016, is that an enforceable undertaking and a change to licence conditions are not regarded as enforcement action?
No, they are within the spectrum of enforcement action. They are not court-based enforcement action, but they are in the spectrum of enforcement action. And I think that's sort of set out in my statement.
And B, that an EU is the mechanism that would ordinarily be used to resolve serious compliance concerns? Court enforceable undertakings are used more commonly when we're not looking to take a court-based approach, but we do use licence conditions. I've just described an instance where we've done so, and in many cases they can achieve essentially the same sort of result, the same outcome that we're aiming for. Is the starting point for ASIC, when it has identified conduct that it considers to breach the law, that it will commence a proceeding?
That has to be considered in these matters. I think one of the points that perhaps didn't come through in the previous discussion is that we will only consider an enforceable undertaking in circumstances where, if it wasn't offered, or if it wasn't offered in a way that was satisfactory to us, we would be able to and prepared to commence proceedings, and with licence conditions that we would seek to impose a licence condition. I mean, last financial year, as an example, we had, I think, around 30 civil cases and around 25 enforceable undertakings. But for those enforceable undertakings, a sort of a threshold test, and the same issue applied when I was a commissioner at the Australian Competition and Consumer Commission. You would not seek an enforceable undertaking unless you were prepared to take the next step should it be knocked back or should negotiations fall over. Otherwise, your enforceable undertaking tool would not, over longer term, have credibility, and I think that's recognised more broadly within regulators.
You see, what you just said was, I think one of the points that perhaps didn't come through in the previous discussion is that we will only consider an enforceable undertaking in circumstances where, if it wasn't offered, or if it wasn't offered to in a way that was satisfactory to us, we would be able to and prepared to commence proceedings.
Yes, I don't want to suggest that in each and every case that we've worked up proceedings, but that is something that Asic, and as I said in my time at the ACCC, is one of the basic sort of considerations that you have in place when you're looking at whether an enforceable undertaking is the right approach. It may offer better alternatives for a range of reasons, but if you don't obtain that undertaking, you have to understand that you would be prepared to take alternative action.
I'm just trying to understand how this view of enforceable undertakings fits with ASIC's regulatory guide, which says we consider that an enforceable undertaking can sometimes offer a more effective regulatory outcome than could otherwise be achieved through other available enforcement remedies, namely civil or administrative action. We will not enter into an enforceable undertaking that does not offer a more effective regulatory outcome. Is that how ASIC approaches enforceable undertakings?
That is part of the decision-making process, but I'm not quite sure what you're getting at here, Mr. Hodge.
Do you see that there are two different ways that you might approach an enforceable undertaking? One way is what you say in your regulatory guide, which is if we've decided that we're in a position to commence a court action, but we think that we could obtain something more with an enforceable undertaking, then we'd be prepared to consider an enforceable undertaking. That is one way.
Yes.
The other way is to say an enforceable undertaking is something that we would look to as a matter of course, but we would only look to it if they wouldn't agree to it, we'd be willing to commence a court proceeding.
I'm not sure that the two are entirely inconsistent, if that's what you're getting at, but we will generally be looking to enter into enforceable undertakings when they do offer the right sort of outcome, and in general a sort of outcome that provides some potential additional or positive or alternatives to going to court. But as I said, part of the threshold test is if ultimately the entity that we're negotiating with knocks it back, we have to be prepared to take the next step.
In the case of Newless, NAB and Newless said that they would prefer to have licence conditions.
I think that's ultimately what was conveyed, yes.
And negotiations then commenced over the terms of the licence conditions.
Yes.
And in October of 2016, ASIC released its fees for no service report.
Our first fees for no service report, that's right.
You've released updates since then.
Numerous updates, yes.
And in the first report, the amount of fees for no service, or the quantum that was referred to in the case of MLC nominees, which is one of the NAB trustees, was $12.6 million.
That's correct, yes.
And then after the report was released on the 3rd of November 2016, representatives of NAB Wealth came and gave a presentation to ASIC.
Yes, I understand that's correct. Though I wasn't at that presentation, but yes.
One of the people who was at that presentation for ASIC was Andrew Mitchell.
Mm.
Is that right? And that was, as you understand it, the first time that ASIC was told that in fact the quantum of the planned service fees was about $34 million.
That's right, 34, 35, around that amount, yes.
But it was at that presentation that ASIC was told that for the first time.
That is my understanding.
And if we bring up ASIC.0061.0001.0001, this is an internal email from Mr. Mitchell to Mr.
Sure.
Tanzer and a couple of others, or three others. Two others,
Yes,
I'm sorry.
yes.
Mr. Tanzer was then a commissioner.
Mr. Tanzer was at that stage a commissioner and the commissioner responsible for superannuation at that stage.
And we see Mr. Mitchell's update back to ASIC about halfway down the page. Today, ASIC was informed that the estimate for compensation for the new notices is approximately $21.7 million, which when added to the previously announced figures for the PSF breach totals $34.6 million.
Yes.
And at the bottom of the page, under the heading Next Steps, Today's update radically revises the previous compensation estimates to a total of $34 million, including interest.
Yes.
And it said, the opinion is expressed by Mr. Mitchell, the revised figure is concerning because the company has known about the events for approximately 11 months and has only just presented the figures in a meeting today, no formal letter and just a hard copy power presentation. We are questioning whether the imposition of licence conditions is sufficient in this situation.
Yes.
Attend to that email, Commissioner.
Email Mitchell to Tanser and others, 3 November 16, Asic 0061 0001 0001, Exhibit 5.319.
Nevertheless, there was a negotiation over licence conditions with Newless, or the negotiation continued.
Yes.
And do you know whether there was any internal questioning of whether there should be a change in strategy in relation to NAB or Newless at this time?
I was not party to any internal deliberations of that sort.
But in your role now, has anybody told you whether there was any internal deliberations about whether or not it was appropriate to continue with negotiating licence conditions, given that information?
My understanding is that the licence conditions were negotiated with North and then imposed soon after that, very early in 2017. But the imposition of those licence conditions did not preclude further investigations into the conduct of North, which were commenced in a formal sense at around that same time, that are now very well advanced and that deal with additional concerns that have arisen in respect of North.
When you say are now very well advanced, you're talking about are going on at the moment.
Yes.
And that's in relation to both the PSFs and also the advisor service fees?
That is in relation to, now this is where I'll need to make sure I've got the terminology correct, but yes, in relation to the fees that were the subject of the $35 million compensation.
That's the PSFs?
Yes. Plus, within Nullis, what we call the sort of no obligation, or the advisor service fees, where customers left the corporate super, moved to the personal super plan, and were charged fees in a situation where there was no obligation on the part of the advisor to provide the advice and that they weren't properly informed. We also have significant investigations underway and well advanced in relation to NAB's fees for no service across other parts of their business in relation to personal advice fees for no service.
And that personal advice in relation to fees for no service would include advice where the payment is being debited from the superannuation fund?
I'd have to double check on that, but yes, that could well be right, yes.
And the first time that Asic raised fees for no service issues with NAB was in about mid-2015?
That's about right. Our fees for no service project kicked off at around that time, involving, as I think you're probably aware, NAB, the other three banks and AMP. So it's a very broad-based project, and we contacted all of the major entities around the issue of whether fees had been paid without advice services being provided across their entities, across the different licensees. We've had 27 investigations as part of that project. I think we've collected more than 2.5 million documents. You can see that we've obtained hundreds of millions of dollars so far in remediation and more to come. And so 31 licensees have been part of that project. So it's a very large project, and NAB was certainly very much a key part of that, and remains so.
So far, no proceedings have been commenced in relation to the Fees for No Service project?
No, so far, that is correct. So far, no proceedings have commenced. We've had enforceable undertakings, bannings, and the licence condition. I would expect that there is a very high likelihood of proceedings commencing in the near future.
And in terms of the remediation that has occurred so far, that is the entities agreeing to pay back money that they shouldn't have taken in the first place, plus loss of earnings on that money?
Broadly speaking, yes, it's a work in progress. It's a very, very significant project, the remediation project, and we have given that remediation aspect priority. You only have to look at the amounts involved to get a sense of as to why. So I think so far there's been about 260 million paid back, but if you allow for the estimated compensation and the provisions, you're looking at 850 million. It doesn't give me any pleasure to say this, but I wouldn't at all be surprised if it ends up being in excess of $1 billion.
Well, just so we can try to put this in some useful context, this is the return to customers of their money that was first wrongfully taken from them dating back to 2008 or 2009.
Around that time, that's correct.
And so far, the actual compensation that's been paid is about $260 million.
That's right.
And ultimately, you expect that at some time in the future, the total amount will, on the present estimate, be $850 million.
That's right.
So there's only another $790 million to go on the present estimate. I'm sorry, there's only another $590 million to go on the present estimate.
You've done the maths well there, yes.
Well, not the first time. And then, assuming it gets over $1 billion, there'll be another 150 million or so to be reimbursed to those customers?
There could well be. I base that statement on the assumption that there will be entities that are not necessarily part of the big five, so to speak, who may have fees for no service issues. We've already had 5 or so breach reports from other entities. And it's also the fact that for the 4 largest banks in AMP, that they are still working through the amount they will have to pay back, especially in their related licensees. Typically, the work is less advanced in those areas, and that's where there's considerable engagement on Asic's part.
And has there been any work to assess what profit these entities have made by having deprived customers of their money over this extended period of time?
That's not something that we have sought to do at this point. It's a good question. I think I'd like to say that, I'm happy to say that Asic will look at that. But I would say up until this point in time, it has been a very, very resource-intensive task to focus on, if you like, the main game, getting money back into the pockets of consumers, and that continues.
Because, and I just want to make sure we agree on this, the customers will be paid back the money plus their interest or loss of earnings.
Sure.
But it doesn't follow, and you wouldn't assume, that the earning that the entity is making on that money is the same or less than the earning that the customer would have received?
Yes, look, I need to give that some more thought, but maybe I'm drawing a link here that might be going a little far, but to my mind, that's one of the points you're making, Mr. Hodges, is one of the reasons why Asic has argued as part of the debate around extending our enforcement power for a disgorgement power, so that we could look to tackle that more directly, the amount of money that's been made by the entities in relation to the misconduct.
Another way of creating a disincentive to deter entities from engaging in this sort of conduct would be to commence civil penalty proceedings, obtain substantial civil penalties from them that would entirely deprive them of any profit they might have hoped to have made from the conduct. Do you agree?
I agree, and I think you will. That has been obviously one of the key issues that we've been considering as part of investigations in relation to a number of the entities that are within scope for the fees for no service issue, and I think you will expect to see that.
Do you know to what extent limitation periods have already been missed because the initial contraventions occurred more than 6 years ago?
I can't give you a comprehensive answer on that, but certainly the limitation period issue is something we have firmly in mind as we sort of plan and prepare for further actions.
When you say you have it firmly in mind, do you mean you know that as every day
There's
goes
a
by-
risk, that's right. There's a risk that for some of these matters we'll run into the limitation periods in a significant way if we don't take action soon. We're certainly alert to that issue.
Now, another issue that arose in relation to NAB and Nulis in 2016 was a proposed successive fund transfer where
Yes.
NAB came to Asic to speak about the continuance of grandfathered commissions.
Yes.
And the outcome was a letter. Can we bring this up? It's asic.0800.0011.3312. I think that's exhibit PK-151 to your statement, Mr. Kell.
Yes.
So this is the letter that was sent to Ms. Debenham of NAB, and it explains that ASIC has been briefed on the proposed approach to the payment of grandfathered commissions following the proposed successive fund transfer,
Yes.
and that NAB have told ASIC that based on its legal advice, it considers that Nulis should be able to continue to pay grandfathered benefits to advisors,
Yes.
and notes that NAB doesn't propose to seek a no action letter from ASIC.
Yes.
And was that the end of ASIC's consideration of this issue?
In relation to, as in this letter, in relation to the grandfathering aspect of that, yes.
And if we go to exhibit PK-150 of your statement, which is asic.0800.0012.1761, and this is an internal email. I think the email addresses are cut off, but it's an email from Ms. Bird to you and Mr. Tanzer.
Correct.
And it's explaining that there's this issue that has been raised by NAB.
Yes.
And then it describes what is ASIC's proposed response, and you see this about two-thirds of the way down the page. We note that NABWealth's letter is unusual because
Yes.
they are effectively letting us know what they plan to do and testing whether we have concerns.
Yes.
And it said, we also note that NABWealth may consider our response unhelpful.
It says that, yes.
And it said, in the alternative, we could consider whether we think a no action letter is needed. However, we have not done so because 1, NAB have not asked us to do so. 2, the law is clearly uncertain. 3, the only relief we could grant is a no action letter, which may be of questionable value to NAB. 4, consideration of whether to grant a no action letter would take some time. The issues have industry-wide implications and raise complex legal and policy issues.
That's correct.
And then when we go over the page, we see that there's an explanation of what is the potentially complicated legal issue about how the platform operator provisions apply.
Yes, that's one of the legal issues, yes.
And so as we understand it, this issue having been squarely raised by NAB, where it was going to rely upon these provisions to continue with grandfathering of commission, ASIC didn't go on to figure out what its position was about this?
Not to any greater extent than the the internal deliberations that led to this email. That's correct.
And I just want to try to understand that. The grandfathering provisions have come in as part of legislation that's recently been passed in FOFA. FOFA's now been in operation since 1 July 2013. I think compulsorily since 1 July 2013. It was able to sort of be voluntarily complied with from 1 July 2012. Does that sound about right?
Yes, the grandfathering arrangements apply generally from 2014.
That was,
Yes,
you had to have
yes,
an investment made by 1 July 2014.
yes, yes.
And there's now a question as to how a particular exception that allows grandfathering applies.
Yes,
And it would seem as if there is an obvious consumer harm issue here because ASIC believes that commissions are not good for consumers.
yes.
And rather than taking any steps to investigate this issue and bring a proceeding to determine the law, ASIC didn't do anything.
Well, we obviously gave the issue some consideration, but given that the law allows for changes, it's pretty expansive, changes to the parties to an arrangement or businesses to be on-sold. Given that there was a high degree of uncertainty, I think the view, as you can see at that stage, was that we simply, in effect, note NAB's view and that they've taken legal advice and that it was not seen as a matter where this was not seen as a matter where testing the law, if you like, would be productive. I mean, I'm summing it up. I'm not saying those were the exact words used, but that's I think where things landed at that time.
And why would it not be productive?
I think the view from our internal legal unit was that it was there was a considerable degree of uncertainty and plus a view that given what the grandfathering provisions allowed, by way of continuing commission payments in the case of changes to arrangements and changes to ownership and so on, that this was not a matter where it would be likely to warrant further investigation. I wasn't involved in the details of the discussion at that stage, I have to say. I know an email had been sent to me, but I think it's, I'm very much prepared to say I accepted the views of our financial advisors team and our legal team at that stage.
You say in your statement that Asic contacted Apra on 27 July 2016 and spoke to the Apra supervisor dealing with the comprehensive triennial review by Newlist nominees.
Yes.
And you've exhibited a note of the contact. It doesn't appear as if you raised with Apra this grandfathering of commissions.
I
Appreciate
don't know that we
person.
did, but no, yeah, except that I have no knowledge that we did.
And with the benefit of hindsight, do you regard this as an acceptable outcome from ASIC's position?
With the benefit of hindsight, I think the question that the Royal Commission has raised here around whether continuing grandfathered commissions satisfies a best interest test, effectively. That's sort of part B of your questions to me. I think with the benefit of hindsight, we should have considered that issue. And we should have raised it with Apra as well. And it's an issue which I would say that we will consider, we should have considered, and we will consider it. I heard the evidence over the last few days from the relevant witnesses from NAB and Nullis about that aspect of this matter. I wouldn't want to suggest that I have formed a view on it, but I didn't find some of the reasons put forward as to why grandfathering should continue and might be in the best interest to be particularly persuasive, but I think that's something that we would need to consider. I think there's also a bigger issue here, and if you indulge me for a moment, Mr. Hodge, I'd like to make this point. Leaving aside the legal test, grandfathering, the entire provision is not in the interests of consumers. The Parliament has in effect put in place a provision that enables the continuing payment of or commissions that generate conflicts of interest and unnecessary costs widely across the financial system. It was depicted as a transition issue of a relatively modest or limited nature. It's actually an extremely expansive provision, both in terms of the circumstances under which grandfathering is allowed to continue and the time period over which it may continue into the future. We can and should look at individual cases, but I think for the interests of consumers in the financial system as a whole, it would be highly desirable to have this dealt with at a policy level.
Now, accepting that that's your view, one of the things you presumably could have done in 2016, consistent with that view, is to challenge this proposition that the trustee of a superannuation fund is a platform operator and on that basis able to grandfather commissions. Yes,
that would be a obviously a very technical argument. With the benefit of hindsight, I wonder whether the best interest issue would have been a more productive way into the matter.
It might well be that that is a simpler way to...
Yeah, and that
attack
was,
the issue.
and as I said, we didn't consider that at all. We should have.
Now, I want to move then to another part of your statement where you talk about some investigations that Asic has been undertaking in relation to the transition of ADAs to MySuper.
Yes.
And you deal with this commencing at page 26, which is asic.0800.0013.0026.
Yes.
And you say at page .0030, paragraph 110, on the basis of material reviewed at this stage, ASIC is of the view that there does not appear to be a systemic issue with the default transfer process, including disclosure.
That is on the basis of the material that we looked at as part of the project that's described in the preceding few pages. I would have to say, given the evidence I've heard in the last few days, I think more broadly there is a systemic issue, but the work we undertook was to look at the transition to MySuper through the prism of advisor behaviour based on an anonymous complaint that we'd received, looking at it through the extent to which authorised representatives, as in advisors and advisory firms, had potentially engaged in conduct to avoid transitioning their clients across. We have certainly identified a series of cases there where we are taking follow-up action, including potentially banning action. But we did not find, as part of that project, that through looking directly at the advisors, that there were large numbers of advisors who were engaging in practices that were problematic in this context. I accept that prism is not the broader prism around how trustees and wealth management firms were communicating it, and so I would just say that's the context of that comment in 110.
We then move to another topic, which is general deterrence, and you express some views about how ASIC regards general deterrence. And if we go to page 43, which is .0043.
Yes.
You make a point at paragraph 154 that ASIC's view is that with large money flows involved in superannuation and the financial futures of so many Australians linked to the outcome of their superannuation, it is most important that misconduct and/or poor practices are broadly deterred. Does that mean deterred through enforcement action in the nature of civil litigation, or do you mean something? Do you mean other types of deterrence?
Certainly, civil or other litigation is a critical part of general deterrence. And in that statement, I'm expressing it broadly. Deterrence can also be achieved through other enforcement mechanisms, through administrative mechanisms, through licence conditions as well. Oh, sorry. But I would very much agree that civil litigation is a key component of general deterrence.
paragraph 201 of your statement, which is page .0055, you say, when ASIC is provided with the right enforcement toolkit, it can use that toolkit where appropriate to achieve a deterrent effect in respect of others in the industry. And then at paragraph 203 over the page, if ASIC were to have a greater role as a conduct regulator for RSE licensees, then it would need to be provided with powers that enable it to carry out appropriate public enforcement action and have appropriate sanctions imposed. I wonder if you can help us with this. As it stands, ASIC may not have very many explicit powers or any real explicit powers under the SIS Act to bring civil penalty proceedings. But under the Corporations Act and the ASIC Act, it can bring civil penalty proceedings for false or misleading representations that are made by entities in relation to financial services. And that would presumably include where a trustee or a wealth management group makes false or misleading representations to members concerning their superannuation. Do you agree?
Yes.
And it has powers to commence civil penalty proceedings in respect of directors' duties. That's right?
Yes, yes.
And do you agree that presumably the directors of a corporate trustee fundamentally need to ensure that the trustee complies with its obligations to act in the best interests of members?
Well, ultimately, yes. Yes.
And if the directors of the trustee failed to exercise due care and diligence so as to ensure the trustee acted in the best interests of members, ASIC could commence a civil penalty proceeding for that.
Yes.
And ASIC has the power under the ASIC Act to commence a proceeding for unconscionable conduct.
Yes, obviously.
And conduct of a corporate trustee or a wealth management company associated with a corporate trustee in relation to a superannuation product issued by the corporate trustee would presumably be conduct that, if unconscionable, would be caught within the ambit of the ASIC Act.
I would expect so.
And that would be another basis upon which ASIC could commence a proceeding for unconscionable conduct.
Yes.
And has ASIC commenced any proceedings against corporate trustees for either false or misleading representations or unconscionable conduct?
I do not know that we've done it for unconscionable conduct. And I would have to check on false and misleading, but if we have, not many actions.
And has it commenced any proceedings for contraventions of the director obligations? I think that's part 2.7 of the Corporations Act, but I might be wrong about that. But in any event, sections 180 and onwards, has it commenced any proceedings seeking civil penalties against directors in relation to their conduct of corporate trustees in the last 5 years?
I don't believe so in the last 5 years, but again, I would have
In the
to
last
check.
10 years?
Yeah, I would have to check.
Were there any proceedings commenced against the directors of Trio?
I think there were, yes.
So that may have been...
Yes.
All right. And so what I wonder is, when you say ASIC would need to have more powers to have a greater role as a conduct regulator, is that a statement that you see as being easily reconcilable with the fact that ASIC already has a number of powers which it doesn't exercise?
I think that paragraph is a reference to the powers or provisions under the SIS Act. And there is an issue here as well around, given you have, for want of a better phrase, the frontline legislation, where ASIC only has a relatively limited set of powers, it would perhaps be desirable to clarify how and where you would expect conduct regulation to be most appropriately housed. I think we would want to we are wanting to undertake further, but having said that, we are wanting to undertake further enforcement action in this area. We've recently received additional funding to do so. It's part of our plan to expand our approach to the regulation of the super sector.
Do you think on the whole, I'm sorry, I said part 2.7, I think it's actually part 2D.1
Yep.
in relation to the director's duties. Do you think that the way in which ASIC has gone about commencing or not commencing civil penalty proceedings in relation to, say, the advisor service fees issue or the plan service fees issue gives confidence that ASIC would, if it had expanded powers under the SIS Act, exercise those powers in a way that would deter misconduct?
I would point to the fact that we've already had some outcomes against the entities, that we have significant investigations underway which are likely to lead to litigation, and that we've obtained hundreds of millions of dollars in compensation to date, as an indication that we take these issues very seriously. I would also point to the fact that we have a more expansive track record of litigation in relation to those parts of the broader superannuation sector where we are the sole regulator or the frontline regulator. So to give you an example, the actions that we've taken in relation to financial advisors who advise on superannuation, or indeed licensees in that space. The National Sterling Group, the first case we took to court under the new best interest provisions against NSG, effectively involved a model whereby the advisors in that firm were inappropriately rolling people over into expensive or inappropriate superannuation products, selling inappropriate insurance, which was then coming out of that superannuation, their superannuation. So within those areas where we have been the sole regulator, much of our work relates directly to people's superannuation and how that is impacted through poor advice or misleading or deceptive conduct.
You don't think, though, do you, that the reason that ASIC has not commenced, there's a lot of negatives, let me put it a different way. Are you suggesting that a reason why ASIC has been reluctant to commence civil penalty proceedings in relation to the conduct of RSE licensees is because of some confusion about its role, because Apra has primary responsibility under the SIS Act?
No, it's I'm simply pointing out that there are provisions under SIS that we are not responsible for, that would potentially provide the ability to take those sorts of actions. I'm not saying it's because of a confusion around that issue.
You mean if you had a power to commence a civil penalty proceeding for a failure to comply with the best interest duty, you might do so?
Or the sole purpose test I had in mind.
That's something that Apra presently has the power in relation to, the sole purpose test.
Yes.
So if you were able to do it, then you might do it.
That's a potential example.
Commissioner, I don't have any further questions for this witness.
Mr. Kell, you've spoken a lot about civil penalty proceedings. Do you regard civil penalty proceedings as the best ultimate means of achieving public denunciation of misconduct?
I think they can be a very effective means, but it will, Commissioner, depend on the circumstances. It might be that criminal proceedings are, in some cases, an appropriate tool. It might be that, in other circumstances, banning someone for life from the industry in which they're working sends a very, very powerful message as well. But certainly I would say that civil penalty proceedings are a very important part of the deterrence toolkit.
If criminal proceedings were to be launched, that would have to be by the Commonwealth DPP, would it not?
That's correct.
And the process would entail Asic submitting a brief to Commonwealth DPP for consideration by the Director whether the circumstances are fit for prosecution.
Indeed.
And do not answer this if the answer would embarrass current considerations, but has Asic in the last 5 years given consideration to submitting a brief to Commonwealth DPP in respect of any aspect of the fees for no service matter?
Yes.
Yes. Mr. Hodge?
Nothing from that, Commissioner.
Yes. Mr. Collinson?
No questions.
Yes. Thank you very much, Mr. Kell. You may step down.
Thank you.
You're excused.